Common Mansplaining, ladies and gentlemen, we are back. At least I hope we're back. Christian should be here any moment. I hope. I pray. I hope he's going to make it. But if he doesn't, we'll keep trucking along. I talked to him earlier today, so everything should be legit. Welcome to Common Mansplaining. What's up? What's up? What's up? Hopefully Christian is on his way here soon. I hope. And hopefully he'll be here any moment. But anyway, we got a lively one for you today. We're going to talk about judicial review, judicial overreach. A lot of stuff with the judicial branch of the government. We're going to talk about what their place is in our American government. I want to apologize real quick to everybody for my angle. Normally I have a kind of a more front on angle, and now you're kind of like looking up my nose and stuff and looking at the ceiling because of I'm having some trouble with my phone. My phone's charger isn't working correctly, so it may look like my eyes are out of focus for a moment here and there just because of the position of the phone. But in any case, so yeah, we got a big one. Hopefully Christian will be here any moment. I'm hoping. I don't know where he's at. Hopefully he's able to join. But in any case, I'm going to get started. So, today's journey is all about the judicial branch of the government. There are three primary branches of the government. That is the executive branch, the legislative branch, and the judicial branch, right? Simple enough. Now, the executive branch is like essentially the presidency and the cabinet and everything under the president's wing. The legislative branch is essentially Congress, right? Senate and the House. And then the judicial branch is all of the court systems, right? Now, one thing to note in recent days, you've probably seen a lot of things about the courts because they've been filing a lot of injunctions to stop Trump. They've been challenging a lot of different laws lately, and this is something that is within the court's purview usually, right? It's something called judicial review, and that is anytime there's a challenge to a law, they will put it in front of a court, and the court will decide whether or not it is in fact constitutional to perform that law or to enact that executive order. It also counts for executive orders too, right? Because we're bound by the Constitution. No matter what we want to do, we're bound by the Constitution. We got to do whatever the Constitution says. And if like a president, just kind of like runs off into the stratosphere and does, things that are not on the Constitution, we have to have some way to hold it, to rein it in, right? Same thing for the legislative branch. Say hi if you're out there, guys. Welcome to Common Mansplaining. Say hello in the chat, and we'll get this thing cranked up. But so with regard to the judicial branch, it is largely a conservative branch by nature, right? Because the Constitution is an old document. The Constitution's been around since the founding of the country and hasn't really changed very recently. I mean, like, I guess the 24th, 25th, 25th, 26th Amendment or whatever. You've got amendments that are more recent, but for the most part, the Constitution stays the same, right? It doesn't change very often. It takes a lot to change it. It takes a super majority to actually move to either repeal or add an amendment. So you're talking about a document that really doesn't change that much. And when judges weigh that against judicial review, it's conservative by nature because they're hearkening back to the time when the Constitution was put into place, right? So even if you are a progressive judge, theoretically, you should be essentially a conservative when it comes to the law because the law is conservative by nature. All right. So that's one of the things that we're dealing with here is this tension in the law between, like, essentially it's like you're either an originalist, which is somebody who basically anytime the law is stated or reviewed, you are the kind of person that looks at what the law was originally designed to do, right? That's what an originalist is. Or you could be a textualist, which is somebody who basically looks at the law as written and does whatever the law says as written, even if it's not what it was designed to do or if it's no longer serving a purpose the way we hoped it would, right? And we'll give some examples of those here in a little bit. Or you could be a progressive, right? You could be somebody who basically wants to use the law, the court systems to make your own laws and to like rule in a way that would essentially legislate, right? It's called legislation from the bench. And it's strictly speaking, it's not really allowed, right? It's not technically what we're allowed to do with the courts. The courts are not supposed to be the legislative branch. We already talked about it's a completely different branch of government. Courts are supposed to be in their own lane, right? They're supposed to follow up behind the legislative branch to make sure the legislative branch is doing what they're supposed to do. All right, so one thing I want to talk about today was Roe versus Wade, right? This is one of the classic cases that demonstrate the tension of these like various legal philosophies, right? And Roe versus Wade is one of those things where when it was originally brought in, hey, Saf Dookie, welcome aboard. Welcome aboard. So Roe versus Wade is one of those things when it was originally brought in, it was kind of like a shock to everybody. Kind of a shock to everybody. It's one of those things where everybody thought that it was unconstitutional. Matter of fact, even liberal scholars like Ruth Bader Ginsburg, people who are very much in favor of abortion, essentially, thought that it was unconstitutional to do the Roe versus Wade and to codify it nationally, right? And one of the problems is it's not really a national power, right? It's something, morality is something that we've always kind of delegated to the states, right? So one of the things that Roe versus Wade tried to do was it tried to squeak this kind of law in based on right to privacy, right? But if you guys know the Constitution well, you know that there isn't actually a right to privacy in the Constitution expressly. What there is maybe an implied right to privacy in the confines of your own property, right? And only in the confines of your own property, right? So, like, you have a kind of right to privacy in that, like, there's an amendment that says soldiers can't come in and quarter at your house, stay at your house without your permission, right? There's an amendment that says people can't come in and search your house without a warrant, right? Without a probable cause. And so there's all these rights that basically say that your property is sanctioned, is holy, basically can't be messed with without somebody having a legal reason to do so. But there isn't actually a right that just says you have a right to privacy, right? And so if you went out and performed an abortion, like at an abortion clinic where most of them would be done, you don't really have a right to that. That's not a right to privacy kind of situation. Now, of course, you have a right to like a client, a doctor-client privilege, which would make it so that what you and the doctor discuss can't be put in front of everybody else. But it doesn't keep what you and the doctor do, if it's illegal, from being tried. So this whole Roe versus Wade thing was kind of like an assailing on the Constitution. It was basically like judges legislating from the bench. It was basically like them saying, hey, look, we just kind of want abortion to be the thing, and therefore we're going to make it the thing, even though they didn't technically have the power. Hey, Tanya, how you doing? So when a progressive judge tries to do that, when they try to legislate from the bench, it's really not it's not technically something they're supposed to be able to do. It's really against their branch's purview, right? If you go into the Constitution, there's an article for each branch of the government, and the judicial branch doesn't have the right to just start making laws, right? So that's a complicated situation. Obviously, we know now that Roe versus Wade was unconstitutional. That's why it was overturned by Dobbs, right? And so this is a kind of a classic example of people trying to legislate from the bench and just trying to like push out the laws that they want, even if it's unconstitutional. And one of the problems with the Roe versus Wade was like there's like this weird balancing test, right? So it was like they wanted abortion, right? And they wanted to legislate from the bench, but they didn't want to like go all the way and say like, all 9 months someone could have an abortion. So they kind of put it in this weird like limbo area where you could like for the first trimester, the federal government sealed it off. And then for like the remaining trimesters, it was kind of like states legislation. States could pick their own laws based on what they want, which doesn't make any sense, right? Like if it's the case that you have the right to privacy and you can do it whenever you want, then you should be able to do it whenever you want. And if it isn't the case, then you shouldn't be able to do it at all, right? So it's not like it shouldn't be like a halfway thing, right? It doesn't make any sense. Man, I really don't know where Christian is. I thought he would be here by now, but anyway, I'm gonna keep plugging along. Hopefully I have enough material without his commentary. Um, so another big one, a huge one, in my opinion, that the judicial branch has neglected is the 10th Amendment. The 10th Amendment is probably the most ignored amendment on the face of the earth. Like, I would challenge you to add, most people probably don't even know what the 10th Amendment is, right? But the 10th Amendment says any power that isn't specifically delegated to the federal government, primarily Congress, because Congress makes the laws, right? Any power that isn't specifically delegated to the federal government. Hey, Tiffany, how you doing? If it's not specifically delegated to the federal government, it automatically becomes a state power or a local power, or it goes back to the people, right? That's the 10th Amendment. And the reason that the 10th Amendment was put into play in the first place is because, remember, the Bill of Rights comes in right after the Revolutionary War, right? And we were just getting done with trying to get away from a tyrannical government, right? England was big and powerful and tyrannical, and they were oppressing us. And so we set up all those Bill of Rights basically as a failsafe to keep that from happening again, right? Like we were thinking that, like, at the very least, what we don't want is for England, like a big tyrannical central government, to oppress us and to take over all of our power, to take away all of our freedoms. I'm really sorry to hear that, Tiffany. I hope you do feel better. So the 10th Amendment now, though, doesn't really have any teeth, right? So there's a lot of things that happened, right? And again, it was legislation from the bench. It was essentially the courts deciding for the nation that this is just how it's going to be, even though it's really not their purview. It's not their job, right? One of the things that they enacted was the New Deal, right? So when FDR came around in the late 30s, basically, he enacted the New Deal. And granted, he was dealing with the Depression. He had just come away from a world war. We were prepping for another world war. So there's a lot going on, right? And he used a lot of what was going on to scare people into his ideas, right? And to scare people into taking on programs like Medicaid, Medicare, Social Security, right? And in theory, they were all situations that, excuse me, gotta move around a little bit. They were all situations that might have been relevant or necessary at the time, but in in the abstract, overall, they were all just things that violated the 10th Amendment, right? Social Security is a violation of the 10th Amendment. Medicaid, Medicare, even stuff that's more modern is a violation of the 10th Amendment. And the reason that they're doing it more frequently is because they look back at that one precedent. This is how most of law works. They look back at that one precedent, they see that it was messed up then. They're like, oh, well, this must be how we're doing things. And so they continue to do things. So, like, a more recent example of a violation of the 10th Amendment would be the Affordable Care Act, right? See, these things, if you'll note, like, if you go into the Constitution and you look, things like education, the federal government isn't supposed to do that. Healthcare, the federal government isn't supposed to do that. It's not in their list of enumerated powers, right? Medicaid, Medicare, on down to Social Security, on down the line, like a lot of the federal grants, a lot of the federal regulations and oversights, the federal government doesn't have that listed as their enumerated power. And the 10th Amendment specifically and expressly says if it's not given to the federal government and if it's not prohibited to the state, then that, in which basically catches everything else, then it goes back to the state or local governments. Put your name here. Says Constitution might as well be a comic book. It's not real anymore. Well, it is real partially, right? We got Christian. Maybe. Is that him? Yeah, I think he came. Woo! We made it.
Sorry.
What happened?
Just problems with the phone. Had to charge it. Sorry about that.
All right. Well, me too. Actually, my phone's been having trouble with charging, but I got it charged in right now, so hopefully it'll last while we're doing. But anyway, so let's see. What do we talk? We talked a little bit about Roe versus Wade. Did you have anything you wanted to chime in about that?
Well, Roe versus Wade is just rather than the issue itself, but is indicative of 20th century liberal judicial policy.
Right.
That the left wants judges, especially Supreme Court judges, but all judges, to just be able to see an end, what they want, a law that hasn't been acted, like women having the right to an abortion up to the first trimester, and then just create it out of whole cloth. Create a new right. You now have a right to this benefit, and the legal justifications don't really matter to them. It's if it's a good thing. So the fact that even Ruth Bader Ginsburg years later said that the 14th Amendment was a lot better place to create a foundation for that, but he just made up this right to privacy. But at the time, right, coming from the Warren Court, that was what the majority did.
Yeah.
Right? And right judicial philosophy or conservative judicial philosophy was, what was the intention of this in the Constitution when it was created, right? In good faith, rather than trying to parse that by different language or different things. What was the originalist intent? And gradually the court had to be remade until we got to that point. And so not just to, I mean, obviously the goal was to fix a bad decision, but it was also to root out and make these type of legislating from the bench much more difficult.
Right. And of course, like I was talking about earlier, when you legislating from the branch is essentially just unconstitutional, right? Like that's not their lane, right? The judicial branch, that's just not what they do. The legislative branch legislates, and the judicial branch judges whether or not the legislative branch has legislated according to the already designed document, the Constitution, right? And that's we also talked. I'm just getting into the 10th Amendment, basically, how it's ignored now, and basically, nobody pays attention. One of the biggest problems is that during the New Deal, right, FDR basically got not only did he use the Depression essentially and the prep for a new world war, which was kind of like on the cusp, as kind of like a fear tactic to get people in motion and to like approve what might have been like reasonable at the time, right? But even so, now it's like everybody just looks back at that and they see the massive change that created in the Constitution. Because one of the things that did is it basically redefined the words general welfare, right? Like one of the things in the Constitution, for those of you guys who study it at all, the Constitution says that the Congress basically can provide for the national defense and the general welfare of the people. Promote the general welfare, right? And not provide, but promote the general welfare of the people. Now the problem is, if you don't have, right, obviously general welfare is like a vague, nebulous term, and if you don't have very, very specific things that are listed, which there are on the Constitution as enumerated powers, if you don't have those specific things, you could open that up to anything, right? Like there is literally zero laws that the legislature could pass that they couldn't at least claim are for the general welfare of American public, right? Like I could say, hey, look, I want to get rid of all fish for the general welfare of the American public, mind you. I want to make the new legal smoking age 97 for the general welfare. Like you could literally do anything and just use that as the excuse. And so, of course, back in the day, that's where the 10th Amendment had some teeth, right? Like it was like, look, these are the lists. And if it's not on this list, it's over here in the States. But now it's like, if it's not on the list, we just add it into the bottom and call it general welfare. And it's like, no, that's not what it was designed for.
Well, yeah. And I would say, like, you made the distinction between provide and promote. And promote, right? I feel like the Constitution and the federal government especially is just to create a social structure of fairness where that general welfare, where prosperity can happen. They can't create prosperity, they can ensure prosperity, but to create a framework, social structure where that can happen.
Right. Exactly. Yeah. And so, it's there in the Declaration of Independence too. It's like, we have the right to life, liberty, and the pursuit of happiness, not the right to life, liberty, and happiness, right? There's a huge difference there, right? And so people confuse like being able to attain something and just having it, right? Like those are two different things. And that's basically the same thing that we drew a line with here. That's what the founding fathers did, right? They're like, look, you have the right to, promote the general welfare, but we're not just going to like give you general welfare all day long, right? That's not
Well,
what it's designed to. But anyway, I mean,
ask the golf chick who's managing Hot Topic how she doesn't want to pursue happiness at all. She wants to pursue darkness. And say,
right. Yes, indeed. Well, hopefully she doesn't get away.
Yeah.
But yeah, so like a lot of these like federal grants now are kind of like overreach. The Department of Education. So a lot of the stuff that Trump is doing now, and I was speaking with one of my friends about this earlier. Tanya actually, we're talking about it earlier. A lot of the things that Trump is doing now by getting rid of these things, he's really just upholding the Constitution. Really, all he's doing is saying this is really not constitutional, never was, and it's not working. So let's just get rid of it. You know, like let's just put this back in the states because it was always supposed to be in the hands of the states. And yet, over and over and over again, he's getting hit with injunctions. And so now we come to the injunction the injunction battle against Donald Trump. And I just want to go over this real quick. There's a study recently done by the Harvard Law Review that basically said that since 1963, over half of all injunctions were done against Donald Trump in his first term. And that's not even counting the ones in his second term, mind you. That is 1963 to 2023, right? So over the 60-year term, over half of all injunctions in America were all against Trump. And 92% of them came from Democrat judges, right? So it's obviously like this heavy partisan bias. Whereas, like, if you would flip it over, like the injunctions against the other presidents are far more bipartisan. It's like everybody's against it because it's just against it, right? But when it comes to Trump, it's just like no, that's bad because he's Republican, you know.
Well, Howard Clegg here, one of the comments, right? The opponents of the Constitution originally were worried that it made the federal government too powerful, right?
Yeah.
Right now, when we were the Articles of Confederation, the federal government was too weak, and so we responded with the Constitution that we have now. And the liberal government wants the government to be more power in the federal, and have it create all these promote general welfare. Well, right, Trump is just using common sense and saying this shouldn't be. If you want this, do this in your state. There shouldn't be anything that the federal government does. But gosh, people love a bureaucracy, and people for some reason, love a law and don't want it to go away from the federal level.
Of course.
So, I'm like, hey, if you love this so much, you can still do it. New York,
right.
California, the places that are going to shop for these injunctions. If you want this, you've got super majorities in your legislature. You can do this. You don't need the federal government to provide this to you.
Right. And so, one of the things that Christian kind of just touched on is that you can basically forum shop. So for those of you guys who are a little bit less familiar with this process, basically anytime, normally if there was something that was going on and you had somebody like, let's say you had some people that Trump wanted to deport, right? And then somebody wanted to file an injunction to keep them from being deported, right? Like, let's say they want to challenge the Alien Enemies Act or some other mechanism that Trump is using to deport these people. Normally what they would have to do is they would have to go to the district that the parties are having the complaint from, right? But in today's world, what they do is they just go to whatever district is likely to give them the answer that they want, right? So they'll just like shop around, find a judge that they like, find a judge that will say, no, Trump, you can't do that. Whether it's constitutional or not has nothing to do with it. They just find the right person, then they go there and then lay that before the judge's feet. And then one of the biggest problems that they're running into right now is, for some reason, even though that's just like a local district judge, he's able to make this injunction for the entire nation, right? Even for other courts that may be legislating the exact same thing and legislate in the opposite direction.
Yeah,
right?
It stops the executive branch from functioning. The injunctions do for the
right,
and that should be an extremely right. If judges have that power, it should be used sparingly, right?
Yes.
But now, right, people are gaming the system. And I always say when people are gaming the system and trying to exploit it is when you have to say, okay, we can't allow you to do that anymore. This is an emergency function, but you're acting like child. Now you can't have this. And so we need to basically reduce district court judges' power. And I think the Supreme Court will do that. They sounded very the arguments this week about the Patriot War Powers 1798 thing, which left the injunction in place, but sounded like they were ready to give a ruling on this. And really, if anything, the Justice Department executive branch should be able to write a rule for the judiciary that says district court judges can't do this anymore.
Well, actually, on that note, there is a bill in the House that just passed, HR 1526 passed, that'll basically say that it didn't really mention the districts that they're in, but it did say that their injunctions will only count for the parties that their plaintiffs basically cover. So that'll help.
Standing.
Which makes perfect sense. I mean, that makes perfect sense. But the other thing, the other problem that's going on too is that, like in the beginning, you guys, if you remember, we mentioned that we have three different branches, right? The executive branch, legislative branch, and the judicial branch. They're supposed to be what's called co-equal, right? They're supposed to essentially be a check and balance for each other, like a perfect rock, paper, scissors kind of thing, right? Now, obviously, it's not perfect, but it's supposed to be as close as possible, right? So the powers of the executive branch are supposed to be relatively equal to the powers of the legislative branch, just in a different zone, which are supposed to be relatively equal to the powers of the legislative branch. Now, the problem with these universal injunctions is you talk about like if I'm the president and I want to do something and I put out an executive order, well, I've basically got to win in every single court that's tried against for my thing to go through, for my agenda to continue. But the district courts only have to stop it once, right? Out of all the districts in America, you only have to find one little itty bitty baby district court judge, not like the Supreme Court justices. One little baby district court judge can shut down the entire executive branch, right? That's not co-equal. That's not even close, right? It's like 100 to 1 or something like that. That would outrageously stifle the power of the executive branch, and there's no way that we can operate like that. Can you imagine?
And the lengths that they're expected of action that they're trying to even now compel activity in the executive branch, not even just put temporary stops on it, right? They were saying, no, we compel you to go back and talk to the president of El Salvador and negotiate in foreign policy with a foreign nation, something that, has never been, clearly never been delineated as power that the judiciary can compel foreign policy, compel negotiation or diplomacy, right? It's not within their power. I mean, one of the weaknesses that the judiciary feels really, really powerful when the Supreme Court makes a ruling that both Congress or both sides don't like, or the executive doesn't like, whatever. But ultimately, they have to have a case, brought to them. And people talk about, if you want to overrule the Second Amendment, all you have to do, if you pass a law that said guns are gone, or we take all the guns, or guns are illegal or whatever, and nobody files a case, the Supreme Court can't do anything. But as soon as the Supreme Court can't act out for something clearly unconstitutional, can't go out and say that until someone files a case. Now, somebody obviously would in that case, but you can have what you had during FDR's time. Is he created this environment where fear and felt like it was such necessity that he was pushing the envelope on constitutionality and trying to fearmonger people into not making cases. And so they sort of let these bureaucracies exist longer than they should have.
Right.
To be rooted out and and allow things like what ultimately Carter and the Department of Education sort of did. You were laid that groundwork in FDR's to do things that were unconstitutional, but this greater good, that we're providing good government. We're now providing for the general welfare kind of thing, was to stifle court cases because they knew, or until FDR, one of the things FDR did too was he stacked the court.
Yeah.
Right. He
Or
expanded the
threatened
court
to, right?
because he knew, right, as soon as anyone made a case, if the Supreme Court was facially a facial charge is this Constitution on its face, that good legal
Right. Of course.
Supreme Court justices would have to overrule it. And
Right.
so he stacked it with a bunch of people that, right, like Blackmans, that could just didn't feel bound by the Constitution. But he was very, loosey-goosey, and the end result is what mattered. And that backed up his policy for a while, and it took a long time to counteract that. But that judicial environment that we live in today, thankfully, is not one of that, and is one of originalists. And you have to bring, and any case, any law enacted or thing can, on its face be challenged as unconstitutional. The issue is that it's not been that there isn't a legal basis to challenge Trump's. It's merely just been naked opposition to Trump's, because when it's been come down to, the Supreme Court has largely upheld his claims as constitutional.
Right. Yeah. So I'd like to ask Tanya. Tanya says that things don't seem balanced and it seems one-sided. So I would agree, but I think it's funny because I'd probably agree in the opposite direction than you're thinking. But I'm not sure, because I'd love to hear what you're thinking to a greater extent. In what way are you seeing things as being unfair? In what way are you seeing them as one-sided? Because I would say that the problem is right now that they're very one-sided in favor of the judges, right? That's the problem. I would say that the presidential powers are supposed to be much greater than they are right now, and they're being halted by a bunch of judges with agendas, right? And that's part of judicial review is constitutional. They have the right to review a law, but only in so far as it affects their district, really, is the way that I see it personally. Although that is going to be legislated. Some of it might be legislated, some of it might be ruled on by the Supreme Court. But if you've got like 3 different branches, and they're all supposed to be relatively equal, one thing to understand is that the president is supposed to be the most powerful person, right? Because in the legislative branch, you've got 100 senators and I don't know, like 200 some odd, 300 some odd. How many? It's like 300.
325.
25, yeah.
425.
425, 420 is 425 House of Representatives, right? So that's like 500 people that manage that branch. If you go to the courts, you've got 9 Supreme Court justices, and then like this ridiculous mass of circuit court judges and district court judges and stuff like that, right? But at the executive level, you really only have that one dude, right? So if everything is supposed to be even, these 9 justices, Supreme Court justices, should basically be even to the one top executive position, because they're the top judicial position, and which should be relatively equal to 100 senators, right? Of course, it's never going to be perfect, right? Because they all have different lanes that they're supposed to be in. Let's see. Tanya said, "I thought the people are the matter, all of the people." Yes, absolutely, right? So in a perfect world, we would be what you would call a self-government, right? A government of the people, by the people, for the people. The trouble is, and this is the biggest problem. The biggest problem is people don't try. People don't try to govern themselves. That's the biggest trouble. The biggest trouble is like if you were to go around and ask each and every person what they've done to make some of their civic duty active, or to learn about the matters. Like, many people don't even ever get informed. Half the people don't vote. Like, there's just so many people that just don't ever give a darn, unfortunately.
Well, I want to answer Candace Black, Ansible Black.
Yep.
So the judiciary has to have a case. If there's an executive order, right, there could be an executive order that says all judges have to wear ridiculous cartoonist mustaches.
They should.
Right. And if there's not a case, they can't fight against that. So what they have to do is have a case. But the first step is, right, on a lower court, somebody says, hey, I oppose this. This is unconstitutional, compelled, whatever speech. This is compelled speech, whatever. And then that district court would say, all right, well, let's just sort this out. And then say, oh, wait, it's going to take us 2 years before we can come to a decision on this. So in the meantime, wear the mustaches. And they say, well, I really don't want to wear these mustaches. Okay, then we'll put this law on hold, and we'll have an emergency. We'll speed things up on hold where you don't have to wear the mustaches, and we'll review this much more quickly.
Right.
But only the judges in, say, Texas, where this case was made, can stop wearing mustaches.
Right.
Everybody else has to still wear them, right? And then you have the ruling, and the ruling would say, like, okay, this is bad to do. And so now you have a ruling. And so then that would go, if they fought it, would go to the appellate level. But since you have an initial ruling saying that it's unconstitutional, then you can do a nationwide injunction. Then you can say, all right, while the appellates are making this decision for now all judges can right? But to do a nationwide injunction when you haven't had that first hearing, right? That's what's really the problem here. So it's not their job to do emergency. Hey, we feel like this is bad, right? Their job is to hear the legal reasons, the arguments from both sides, right, and render a decision, right? And until that decision has been rendered at even the lowest level where the case is brought, a nationwide injunction is inappropriate, right? Unless it's the most extreme type of thing where I don't know, I can't think of an example.
Well, and moreover, one of the things I mentioned a few moments ago is that you could have these multiple. First of all, they're court shopping, right? So they're not. You could have like this. Let's say they're doing something in Texas, which is where one of these injunctions was to stop deportations, right? If you were to go talk to like all 100, I don't know how many district court judges there are in Texas, but like if you were to talk to all of them, I would bet you that like 95% would have been like, yeah, sure, deport him. Right? No problem. But they found the one guy that's like, I don't really want them deported, so I'm going to file an injunction, right? So it's not that it isn't constitutional. It's that they found the one person who's willing to just say,
like the policy.
And not only that, like literally there could be one person talking to that judge, asking him if it's constitutional. There could be somebody talking to another judge in a neighboring district, and that judge says, yeah, this is perfectly constitutional. And then you've got this battle, right? Like, so then you're talking about one judge shutting down the other judge's decision just because they've put out an international, like a national injunction, even though this judge heard the case, thought it was perfectly legit. And then so it's like it's a really complicated scenario, right? So that's why I think the best case to answer all these problems is if you're the judge that thinks it's unconstitutional, well then you can rule it so in your district, and then we'll appeal it and we'll figure it out. But until then, like if you're putting out an injunction, this is your zone, this is your lane, this is what you control, this is what you should be able to injunct. And then
they're not even ruling; they're just
right. They're just
right. So even before a hearing, even before arguments have been made at all, right? Because judges actually do not enjoy being overturned. It's bad for their judicial record, things like that. So if they're going to rule, they might rule quickly or disfavor policy, but they've got to find solid legal foundation for it, or else they know they're going to be overruled at the next level.
Right.
So when they do a temporary injunction, sometimes knowing that they can't even rule, once arguments come through, they know they're going to have to find the law constitutional, right? Because the Constitution clearly says the executive gets to administer immigration enforcement, right? That is 100% in their lane. They know they're going to have to find that. Even if they don't like the policy, they're going to have to find it legally, but they're like, but temporarily, I'll just stop it.
Right.
And that is when they know that, when they even know they can't rule in its favor, that's the type of I'm doing a favor for my side kind of stuff that has gotten to a point where it's malfeasance. and it's
Right.
gaming the system, and it needs
Right.
to change.
Yeah. Speaking of things that are in the executive branch's like purview, like without any question, one of them is being able to run international diplomacy. Right.
Yeah.
That is far and away the president's job, and to a lesser extent, the secretary of state or the local ambassador for that particular nation.
As
But
delegated by the president.
right.
Yeah.
Right, but that is the president's gig, right? And nobody is supposed to tell the president how to manage international politics, international diplomacy, except the president, right? And so
Well,
now,
all right. What
uh,
one caveat?
as long as
The
he's doing it within
the legislative branch gets to approve the ambassador and approve the secretary of state, right? So they get to
right,
advise and consent, and the Senate gets to approve treaties, right?
right, right,
But the executive writes the treaties, they negotiate them, everything like that. So
right, and of course,
there is some oversight from the
right,
legislative, but the
right,
judicial has nothing involved in that. It's only the
nothing to direct.
legislative.
And
Yeah.
right, and of course, like right, yeah. So the legislature has some other laws, like of course, can't accept bribes and stuff like that. You have to, whatever. There's laws that manage oversight, like he mentioned. But yeah, but ultimately, that is the president's power, right? That is his duty, and it's nobody else's duty. So in this one recent case, where they basically the court ordered President Trump to facilitate the return of Kilmar Abrego Garcia from El Salvador. That's a case where the judges are just very clearly going out of their lane, right? Now, whether or not Trump screwed up, or whether or not his ICE screwed up, or whether or not there was a mistake somewhere in there, I honestly don't even think there was a mistake. I think they did exactly what they were supposed to do. That's me personally. But even if there was a mistake, they still can't make him do it, because like it puts us in a very vulnerable state diplomatically. Because what if Trump goes to Bukele and Bukele says, "No, I don't want to release him. If you want me to release him,
He's an El
give me
Salvador citizen.
yeah, like if you want me to release him, give me $5 trillion." Then what's Trump going to do if he's got an order to do it? Well, he's just going to give away $5 trillion of American taxpayer money? Of course he can't. But he's ordered to facilitate it. So obviously, when they say facilitate, the farthest that could possibly go is if there's a situation where he's figured it out how to bring him back, then he can like pay for the guy's flight or something like that. But like aside from that, there's no way to force the president to perform diplomacy in a certain fashion. It's just way outside their lane. Just way outside.
Yeah, absolutely. And obviously we can talk to them, but right, it is what's frustrating to them is they have to acknowledge it's a constitutional loophole, right? When you take someone who's not a U.S. citizen, right, and return him to the country where he is a citizen, right? If you argue, well, he should have had due process or should have had these rights when he was in the United States, you can even say, okay, but now he's no longer in the United States and not subject to our rights. He's subject to the rights of his country and his citizenship, right? And so, while I also don't disagree with how it was handled, even at the most extreme, if they say, the due process was violated, his Fourth Amendment rights were violated, but now there's really no recourse because he wasn't a citizen and he's back in the country of his citizenship, and that country is under no obligation to send him back to us, right? And the courts can compel that.
Right. And not only that, there's something else. There's in courts, in the legal system, there's something called what's called a harmless mistake, right? I don't know if you guys are familiar with this concept, but basically, let's say you're having a trial, right, and your lawyer screws up, right? Like they make a mistake and they accidentally tip their hand with some evidence or something like that. Basically, your lawyer made a mistake, right? But so you go to the judge, you say, "Hey, I want a mistrial," but the judge looks at it and says, "Yeah, he did make a mistake, but it would not have changed the outcome of events. Everything would have stayed the same, right? Like this mistake essentially does nothing. It's harmless, right?" The failure to provide due process, if there was any failure to provide due process to Kilmer Abrego Garcia, it is far and away inside the confines of a harmless mistake. Because even if we bring him back today, The only thing that's going to happen is they're going to be like, you know what, that withholding is removed. Now you go back to El Salvador. Like it doesn't, nothing would change. So this is what you would call a harmless mistake. So even if there was one, like it's not going anywhere. Nothing would change anything. So again, these injunctions are just a game to like stop the system. It's just a game to hold up President Trump and hold him hostage, basically. We could talk about, let's see. All right, let's talk about gun control for a minute. I have a question, right? So, we in the beginning, I mentioned that there are three different constant ways of looking at the Constitution from a legal perspective, right? One of them is like an originalist, right? Basically, whatever the original intent of the law was, and you perceive that and then apply. One of them is a textualist, someone who just kind of like looks at the law as written, whatever it says, and then applies that. And one of them is like kind of a progressive who just, like you mentioned, they just want to find whatever result they're looking for, right? Now, gun control is an interesting one for me, right? Because normally I would claim that I am an originalist for the most part, but gun control changes that for me a little bit because it's tricky, right? Like they couldn't have anticipated some of the technology that we've got today, right? Like, like arms, yes, but what if someone has a nuclear arm, right? What if someone has a
So I would say we don't have the right to have the same weapons that our military uses against other nations.
right?
But we have every right to have every level of technology of weapons that our government would use against the citizenry to police them, right? To enforce anything. So anything that at the police level or the National Guard level that we would use for national defense inside the country towards citizens should have that level, right? Nuclear weapons we have never used against our own citizenry. If we ever do, then I think, yeah, that would open up a can of worms. Now we can have citizens who can have nuclear weapons to defend themselves. I mean, we never would, but if we ever use a weapon against our own citizens in the United States, then I think it qualifies for Second Amendment protection, right? Anything the government uses. And so that's why it's not just muskets. Whatever the government
You're talking about policing? Like
police weapons.
What about
National Guard that would be deployed in the United States? If they deploy National Guards in the United States and use those weapons, like in Waco or something like that, every weapon that the FBI used or National Guard or whoever ATF used in their assault on Waco should forever be legal to the citizenry. Once the United States government uses a weapon in the United States against its citizens, we are able to have that equivalent in our homes forever.
So let me ask you this, because I think they use 50 cals in Waco.
Yeah, if they don't want us to have 50 cals, they don't want us to have new technology, right? Then they just need to stick to bow and arrows in policing. Right?
Don't get me wrong, like, because here's where I'm at, right? Like, don't get me wrong, I feel like it's one thing for a kid to go into a school and he's got some mental health problems and he hits up the school with a rifle, right? And this is let's say it's an AR-15 and it can fire like 3 shots, and it's still not doing anywhere like the 60 rounds a minute or like 50 cals can go up to like 300 rounds a minute or 600 rounds a minute. That's like he could literally cut a school in half, with that.
And I think that's the only way that we get the government to reserve back and not use their weaponry against their citizens is I would enact codes, at least maybe starting today, that if any police force has a weapon in their arsenal, that has to be publicly available and legal for their citizenry to also own. If the government ever uses that in America, right, that's the standard. So they're the ones who are escalating, right? I think the intent of the Second Amendment that makes the other amendments really mean anything is the citizens can be just as well armed, right, as a militia, right, as their government, right, and keeping a well-funded militia, well-stocked, right, that well-stocked means that they can have everything the government is stocking.
Interesting.
Right.
So you're
and so that's just like it. Even though I'm not a gun guy, I'm a city boy.
that's kind of
Right.
in between, right?
I'm not interested in guns. Right. But I feel like constitutionally or as the rights that this one is so foundational to our freedoms. This right that the government cannot restrict this right, and the government is the one that sets that sets the standard on technology. And if they want that technology to go down, they need to start using non-repeating rifles, small magazines, no
Now,
bump stock.
my brother has an interesting answer, which is more like a textualist answer. Basically, he says that any arm that you can bear, right, like anyone you could hold in your hand. Right. So like 50 cal would be out because you can't physically hold that by yourself. You'd need like a turret or a vehicle, right? So or something like that. Or you'd need
I can show you a 50 cal anti helicopter weapon that you definitely hold on your shoulder. Though the kick on it, there's a video of a guy shooting it on YouTube, and the kick on it was he says it was the most humbling thing he ever did in his whole life. Was like that it just stripped him of ego is like the kick on this thing. But
right.
It was obviously a single load at a time kind of 50 cal.
But, yeah, I mean even arms that you can bear are pretty sick, like javelins and stingers and stuff like that. You can
yeah. And so if they have like, hey, if we're just doing normal patrols, right? This is what we have. But if we're ever going to equip the thought has been if we're ever going to equip our policing or National Guard with certain weapons to use against American citizens, they need to know that will now qualify all those weapons for legal ownership for American citizens, and that'll put some reservations in there that the government should not with impunity be allowed to just use whatever they want and say this is good for me but not for you. Now, foreign wars or foreign militaries, I'm allowed them to the best of the best. But if they're not using that to have power over us, then I'm allowed. That's a judicious. That's wise use of those arms. As soon as they turn those weapons against us, right now all of a sudden, everybody can buy that. And
it's interesting. Now, what about licensing though? Would you at least, because I mean, like police officers do have to go through a rigorous training process in theory, right? You have to get a license, have to do that XYZ. Would you at least require like a license for like an ATV because police have ATVs? Would you at least require a license still for a helicopter because police have helicopters?
Look, I think common sense age restrictions, right, for adults, right, are reasonable.
But not
I think they're right as long as the spirit of the law is because if government's not arming children, then we don't, right. If the government is restricting itself in the same way, right, requiring licensing. One of the big things if a police officer fires a weapon, say you have a gun from a police officer goes bam, 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 right? They have about 10 pages of paperwork justifying each time they discharge their weapon. Right? That's 50 pages. Why all they're thinking to do they have to justify each one of those shots, right? And again, it's we as citizens. If we discharge a firearm in the city limits, we're going to have to come up with real good justifications for each one. So if the government holds themselves to a standard, right, then they can hold us to that standard, right?
Okay. So for example, the government
suspicious of like FBI or people that can have crazy guns that we're not allowed to have or discharge and use them without facing any consequences or review, right? It's this sort of I can just shoot and I don't have to do any paperwork. If that's the case, I think then citizens should also have that same right, right? But if we're licensing government officials, then we can license citizens.
Okay. Well, we do license government officials to do that. I mean, for the most part. I mean, obviously not like CIA, but everybody else. I mean,
CIA is not supposed to be
Not
against
supposed
citizens
to.
on our soil.
But they do. We know that.
Yeah,
We know
and
this.
if they
Yeah,
do, then everything they use against us becomes legal. Right?
indeed,
There
indeed.
should be a website saying, "Hey, this gun was used by this official again in American soil against a U.S. citizen. Buy it here now,
Mhm.
legal." And just
Well,
have a random list.
hopefully it never comes to that. All right.
Yeah.
Well, real quick. So DM, I didn't. You said something about Romania. I didn't quite understand what you were saying. I guess hit us back when you get the answer to my question. What manipulation were you talking about in Romania? Anyway, so Tanya, what we didn't really discuss USIP directly, but what we did discuss is the injunction regarding the USIP, of course, because that's part of the game, right? Part of the game here, and I'll talk with you about USIP a little bit later, but part of the game is whether or not USIP is a good system or a good bureaucracy, like a good agency, doesn't really matter because it's not the court's decision whether or not if Trump declares an emergency, that's well within his power as an executive. And if he declares an emergency and says these people need to go, this basically this
What's
whole agency.
USIP? What's USIP?
USIP is United States. Something of peace. It's not actually about
Oh,
peace anymore.
Institution of Peace, something like
Institution
that.
of peace. Yeah,
Okay.
yeah.
Oh, yeah. Well,
It
yeah. Well,
started out
yeah,
that way, but
yeah.
it is great. The thing about these bureaucracies is that most of them start out with this great idea, but then after they're in, they basically have only one reason to exist, and that is to keep making themselves bigger and more powerful, to keep making
And
expanding
to
their
ensure their jobs go on forever. There's
right.
no constitutional right that federal jobs go on forever. This is one of the injunctions Trump is facing. He should be able to remake the executive and make the workforce a lot smaller. There's no right that once you're hired in the federal government, you get to work there as long as you want.
Right
Right?
now. And the agency, right? The like, all right, you create all these agencies, EPA and OSHA and like a million different things. But the thing is, at some point in time, if the president of the United States declares that there's an emergency and says we need to make some budgetary changes, then he has the right to do that. And there really there's no particular reason why the judge would be able to step in unless, for example, the president violates a protected class when he's doing it, or unless he breaks another part of the Constitution, which not in this case is he doing that. I mean, there are some other cases that are closer, like one I'm going to ask Christian about right now, which is birthright citizenship.
All right, we're going to get to that. I want to just comment on USIP.
Yeah.
Again, USIP just once again was a case of they gamed the system. They went too far. They weren't providing the service they were providing for themselves. And again, not something that's needed. Maybe in the future this could be remade with better oversight. But I agree that for the time it should be eliminated. All right.
So, birthright citizenship. This is one of those cases where, again, a textualist would just read the text as is and say, look, this is what it says, and it says if you're born in the United States, you're a citizen. Right? That's all it says, really. I mean,
no. Let's read it. Read me the text.
Sure, I'll read you the text. Here we go. 14th Amendment. All right. Where is the actual text? Actual text is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws.
Okay, so fuzzy area on this. All persons born or naturalized in the United States. Oh, right. I was going to say and territories, which that's subject to the jurisdiction thereof would be U.S. territories.
Yeah, correct. Although, one thing I would grant is that I personally don't believe that illegal immigrants are subject to our jurisdiction. I think legal non-citizens are, right? Like if you come here and you declare yourself at a port of entry, then you're subjecting yourself to our jurisdiction. But if you come in like you just skip across the border and nobody sees you, I don't think that counts. That's my personal opinion.
Yeah. You're sort of taking the wind out of my arguments there, but that what we've been having is how this is understood, right? If you're born here in the United States or the territories, you're a citizen for life. I will, that's how it's commonly understood, and I think generally I don't have a problem with that. The problem has been that people have been gaming the system, right?
Right.
And that's why, right? The people have crossed into this country illegally, not at a gate, or they've crossed in customs and not declared that they're pregnant and intending to give birth in the United States, which is information we should evaluate.
Right.
And might deny them entry based on that. If they conceal that information, come here and have this child, immediately leave, right? That's the thing when we're talking about gaming the system, especially Chinese that are doing this in Guam has become a big problem. And I understand that because our immigration system is very tied towards reunification of families. Once they have this child, they call it an anchor baby. Now they can enter illegally into the country, have a child, show paperwork that it's a citizen, and then we need to reunify the family by giving us all legal resident status here in the United States. I have to. So that was not how it was intended when it was written in 1868, right? And it's been sort of gained.
Now, so one thing I'll say, like as a textualist, I think it is what it is. Now, as an originalist, like if you were to take the original concept of the amendment, it really didn't have anything to do with people coming into the nation temporarily. Like it really had nothing to do with that. What it was about slavery, right? It was about all these slaves are already in the nation. They're already here. And we're like, whatever, let's just make them citizens, right? Like, never mind how they got here, wonder what circumstances they gained their naturalization process. But we're just like, let's just go ahead and make them citizens, right? And get that right. That was the point of the amendment. Now, from an originalist standpoint, I don't think the point was ever to allow, like, for example, the guy who wrote the amendment, I believe, specifically said not to include like the kids of foreign ambassadors, for example, or stuff like that. But nowadays, right?
Okay,
the other side of this is one way that we determine laws through precedent, right? We've basically got a century of law that says if you've managed to squeak in, then you're good.
Here's my spicy take on this.
All right, let's hear it.
Get ready for my spicy spiky take. So
here we go.
The people, right, will become citizens, right? So some Chinese national, Chinese citizen, takes a vacation to Guam while pregnant, comes to the custom. I'm just here for a vacation. Stay at your beautiful resorts here in Guam. Doesn't declare that they're pregnant. 2 days after they arrive, they have a labor. Maybe it's induced labor. Maybe they go into labor. It's either one.
Right.
They have a child. That child, I think, should be a citizen. But I think that you could write a law that based on when the parents weren't a citizen and crossed here under bad intention to game the system by not declaring things like that, you can then later disqualify and remove that citizenship. Now, not without due process, right? You wouldn't do it. You'd have to have a hearing before a judge and present evidence, but that child would be granted citizenship. But then they say, oh, because the people entered here and their entry and the nature of their birth, the situation, the context, shall we say, of their birth was illegal, we are now going to officially revoke their citizenship and not recognize it. Now, so this would give them, they would be born citizens, but would lose their citizenship because of the illegality of their parents. Right?
Interesting.
If their parents crossed our border illegally or lied on customs. Right now, people who come here, right, and lie on their customs things can have their residency or citizenship revoked.
Right. Right.
Like,
No, I mean, obviously,
that would be a temporary say, please don't game the system. We'd like to act in good faith. You're born here, you're a citizen, but we can't ignore bad actors,
yeah, I
especially
mean,
at the scale that they're doing it. That there are planned like tourism groups like in China promoting this. It is a taught way for people from South America that want to skip the line to get pregnant and go and have their baby for free in an American hospital kind of thing. It's bad for our institutions, and it's not what you said in the spirit of the law. So that would be my spicy take, and the approach that I think would be the most likely to pass scrutiny if a government enacted it. All right, tell me your thoughts.
Well, I think it's a little bit unfortunate that we're punishing a child for sins that that he or she is not personally committing.
Well, the parents are trying to use this child for things the child hasn't chosen to do. They're trying to use this child to manipulate.
Well, so I feel like if the problem is the parents gaming the system, then we should write a law to punish the parents, right? And it sucks for the child who may be, in fact, a citizen here, stuck here without parents because the parents broke a law and like, screwed up. But I mean, I don't know. I mean, obviously, any way we slice this, it's not going to be great, right? Obviously, or like the best case scenario, in my opinion, is we just repeal the amendment or change the wording of it, right? And say, look, if you're born here or naturalized here of citizens, right, or of naturalized citizens, or of people who are here, under legal pretext and have been here for at least X amount of days or something like that, then sure. But like nobody's going to do that because it
doesn't
requires
say
the
that citizenship cannot be revoked, right? I think that they are citizens, but and they're subject to Fourth Amendment. But in a hearing under a judge, right, they can then lose that citizenship, and it's not guaranteed for life. Is what I would say.
Here's my spicy take. You ready?
Okay.
Ready for my spicy take? I think that we should bring back exile as a formal punishment. I think that banishment and exile is just something that's been around since the dawn of time. I don't know why we don't use it, because it's actually rather more humane often than many of the other punishments that we could give. And I say, look, if somebody creates the wrong kind of problem, and like for example, the kind of person we would deport, I would say, look, you're banished forevermore, never come back to the United States of America. A decree here, and that would be. And then for someone like this, or someone who gained the system, you guys are banished. Like that's it, goodbye. And you could be a citizen, but a banished one. You can have a wonderful life as a exiled citizen in China, or whatever. That's my spicy take.
Wow, that would be interesting, right? But again, that would have to be done with due process, because citizens are due process. So you couldn't do that. You can't do that as a class. You'd have to do it on an individual basis.
Of course,
right?
absolutely.
But that is right. Part of it is in jealous countries. Which countries are going to take our exiles, right? But that's another way around. I just think that citizenship for a child born of non-citizens is reviewable and could be potentially revoked. Right.
Right. Say,
really, you're a naturalized citizen of, especially if there's ever any dual citizenship.
Anyway, guys,
going about it directly, just saying no, we're not going to grant these people citizenship. I don't think that would stand up. I think, right.
It's a long shot. That's for sure.
You'd have to have some way to review their citizenship or recognize their citizenship in a banished or exiled state.
Right. All right, guys. Well, look, that's all we had for you today. It was kind of a crazy one, but hopefully Christian will be here on time Saturday, and we'll be able to crank this up.
No doubt. But yeah, I just think it's important, like for the common man, just to realize the elites don't want us to know the Constitution.
Right.
They want to gatekeep knowledge so that they can game it and loophole it, or and hopefully that we won't object to the laws that are infringing upon our rights.
Right.
So it's important for us to understand this, and even when we have spicy takes or we do things that are kind of funny, at heart it's a serious matter that the government is limited by the Constitution. Right? That limits what we're doing, and that's what makes the American experiment different. And
Yep.
we've gotten to a point where our federal government has gotten so powerful, we're losing the distinction between other countries that have, very, very powerful federal governments. That's not the intention of the American experiment. And I applaud Trump for attempting to descale, especially the executive branch that he can.
Yeah,
So,
agreed. Yep. Guys,
that's my closing statement.
Yep, mine too. Arm yourselves. Arm yourselves with knowledge. Read the Constitution cover to cover, and when that'll be the best way to be a powerful common man. Catch you guys next time. Common Mansplaining.
All right.